This is the plaintiff, Charlotte. She says the defendants were her former tenants, and when they moved out, she noticed a chip in the porcelain of her brand new bathtub. The defendants refused to take responsibility. She had to get the whole bathtub reglazed and are suing the reckless defendants for the $515.99 it cost her. These are the defendants, Craig and Kathleen Friedman. They say there was a shower liner in the bathtub and they never saw a chip in the porcelain. They know they didn't damage the tub. The woman said nothing about the so-called chip when she did the walkthrough, and they owe this woman nothing but a curt goodbye. They're accused of taking it out on a tub.
All parties, please hit your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff says she rented a brand new spanking apartment, and when they moved out, the porcelain tub was chipped. Now the defendants say they didn't chip anything, and the plaintiff never noted it on the walkthrough when they moved out, and they're owing nothing as far as they're concerned. It's the case of we're not a chip off the old block.
Been sworn, Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
All right, Ms. Charlotte, you are suing Mr. and Mrs. Friedman, your former tenants, because according to you, they ended up damaging your bathtub. How long did they live there?
It was 1 year lease.
Okay, and tell me what they did to the bathtub.
I'm not sure how it got damaged, to be perfectly honest with you, but it was a brand new renovated bathroom. They were the first tenants to use the bathroom after it was refinished. Okay?
Okay.
And after they left, I noticed that the tub was chipped. We never did a walkthrough. I never was with them to, show any problems that I may have seen wrong. After they left, I saw it, and I notified them immediately that there was a damage to the tub that I expected them to be responsible for.
Let me ask you a question. You had the entire tub reglazed, correct?
Yes, I did.
Is there a reason why you didn't just address the chip and have the chip repaired?
The contractors that I called advised me that the best way to do it was to fill it with fiberglass and to reglaze the tub. Since it was a brand new bathroom, that's the route I decided to take. Had it been an older bathroom, maybe I would have just tried to patch it. But I had just spent a lot of money having that fixed, and I wanted it done correctly.
Right, and no, I understand. If a patch wasn't going to work perfectly, then a patch shouldn't be what you have to put up with. The thing is, a patch could work perfectly, because I've had this issue before. But let me hear from you, Mr. and Mrs. Friedman. I see letters where you respond saying to her, this is normal wear and tear. You're kidding, right? Because that's not normal wear and tear. How did that happen?
Well, as for the chip goes, we don't know how it happened. As for normal wear and tear, I don't necessarily know what it would, on how that would be.
Do you know how that chip happened? Because usually, like, if you chip a tub, you kind of know that it happened. Like, you're like, darn, as soon as it happens, right? You guys don't remember how it happened?
No, to be honest with you. And we even tried to circle back through photos that we had, like when we took photos of the entire apartment, just to see if, you know what, like maybe we screwed up. Maybe we did something. But we don't have any memory of doing that to the tub.
All right, well, in any event, it's a brand new tub. It gets the chip during your watch, and she wants to get paid for it. Now, one of the first things that you said to her in your letter, are you guys attorneys?
No, we are not.
Okay, one of the first things that you, because it was a really good letter.
Welcome back to the People's Court. The plaintiff wants a whole new bathtub because of a chip, but the defendant says it's nothing and it can be fixed for literally nothing. Let's go back into the courtroom.
Did you have the help of an attorney when you sent the letter and the release?
Yes, we did. One of our really good friends is an attorney.
Okay. All right. So you sent a letter to her saying a kit costs $50. I'm willing to offer you $250. Here's a release. And you did not accept that because you actually paid the $500. I understand that, Ms. Charlotte. So really what this case boils down to is whether or not a repair was necessary or an entire reglazing. You have an email from a company giving you an estimate on the repair alone.
Correct.
And that company says it should be about $200. That's a little, I think that's low, but I do recognize, because I've been in this position, that you can perfectly cover that chip and not have to reglaze the whole thing. I think 200 is on the very low side. She doesn't have to use your company, because what happens in court is that you're entitled to the reasonable damages. You're not entitled to more than that. You may end up paying more than that. You know, if you decide to spend $10,000 on a $1,000 item, that doesn't mean that they have to pay $10,000. I'm finding in your favor in the amount of the $250. I think that's fair, plus, of course, your court costs. Good luck.
So the plaintiff gets half, basically, of what she was seeking here in court. I'm not sure she's happy with that, but let's find out exactly what her feeling is. How about that, Ms. Charlotte? Let me ask you first. What do you feel about that?
Well, if that's what the judge decides is fair, then that's fair. I accept whatever she's willing to give me.
All right, very good. Well, thank you very much. All right. How about you, Mr. and Ms. Friedman? What do you feel about that? I know you felt you didn't owe her anything, but the judge says you have to give her that money. What do you think? $250?
We find that reasonable as well, too. We sent Charlotte a letter saying that we wanted to split the difference of the bill that she sent us, and the judge ruled in our favor. So we're very thankful.
You're very agreeable. All right, very good. Thank you so much. Appreciate it. Now let's find out what the judges think about this case. Here's another session of After the Verdict.
Looks like this case comes down to what is normal wear and tear to some extent, and then after that, the question of what's the value of the work that was done by the landlord, correct?
Yeah.
And certainly a chip like that on a porcelain tub, if you chip something off of it, you can't just put white out on it.
No.
There's some kind of science here. There's some kind of artistry to getting it repaired correctly,
yeah,
right?
I presume there are some people, just not you and I, who could repair it on their own. But, you know, you probably want to bring in an expert, yeah.
So setting aside the issue of who's accountable, we both agree on that. I would have given her the full $515.
Yeah.
And I wouldn't have put it on her to shop around for the very best price, etc. I guess.
Do you feel like she was entitled to a full reglazing then, I guess?
Not necessarily, but
or just that the amounts are so
right.
low. That...
I think given the disparity, I probably would have given her the full amount. We can agree to disagree there.
Yeah, and certainly because she actually did spend it already. It's not like she's seeking it and then gonna pocket some money or anything.
She's not a scammer.
No, she's not a scammer
in any
at all.
sense of the word,
at all.
Right? So at the end of the day, I'd have given her the full $515, and you say, well, she's gonna have to take a bath on half of that. It'll be $250 or thereabouts.
Yeah,
plus
it's always a struggle, you know, when you're sitting there trying to figure out, all right, I can only award what is reasonable, but then again, reasonable minds differ on what's
that
reasonable.
Mysterious number that judges are always trying to conjure up. What's the reasonable value?
Right.
Hey, Harvey, a friend has been storing his trailer on my land and I haven't heard from him in 6 months, and he has no family. Can I place a claim for title from DMV and gain ownership? The answer is no. You cannot do that unless you have a lien on the property and it gives you that right. Otherwise, what you should do is treat it as abandoned at some point, and then you can get rid of it legitimately, but don't do it prematurely. See you next time.